asset protection is about estate planning and making sure that for generations, whatever you own or possess goes down through those generations forever without being lost through divorce and some other issues which I'll cover in a second. I mean, a good example of this is the Duke of Westminster, who died a few years ago. He had a huge estate. I think at the time it was about £10 billion. His family, way back when I think it's probably Waterloo was being fought, created a trust, and that trust has allowed those assets to pass and roll down the generations, unaffected from bankruptcies and so on and so forth, and the things that happen in life that can reduce wealth quite rapidly. So today that trust will roll on for many generations. And again, it's a bit like there's a phrase that goes around that wealth is lost on the third generation. A lot of assumptions on that is that it's down to mismanagement or so on, and normally, unfortunately, it's down to the breakdown of relationships, a divorce and so on. So the way I look at it, there are 5 main threats to wealth. One is marriage after death, and what that simply means is that say you've got Jane and John. John dies. Jane inherits all of John's wealth. She then meets an attractive young man, and they get married. And sadly, that relationship doesn't work out. And all of a sudden, Jane is having to give away half of her estate or assets to this new fella because he's entitled to do so under divorce laws. Or worse still, and this does happen, is that Jane actually predeceases the new chap. They may or may not be in wills, and all of her assets are now his. And whatever children Jane and John had can no longer inherit those assets because they now belong to a different family. And that's quite scary how often that happens. And that's probably one of the biggest concerns to a lot of people. More so in some ways than inheritance tax. One of the biggest fears I talk to people who have created wealth for themselves is when their children are growing up and getting into relationships, the last thing they want to do is for their hard-earned money to be dissipated because their beloved little child has got into a relationship that hasn't worked out. There are lots of ways of protecting assets on that basis, and these are called trusts. And they're discretionary trusts, which is a technical term, and basically allows the trustees to control and possess the property, would it be home, savings, business assets, and so on, for the benefit of the beneficiaries, which is an obvious thing. But under law, those beneficiaries don't own those assets. And because of that, they can't be attacked from care fees, from creditors, divorce courts, and so on and so forth. And that's what asset protection is all about, is making sure that those 5 threats can't dissipate wealth down those generations. Another example could be, where, again, Jane and John, perhaps they've got a little lad or daughter who are going off in life and they want to buy a property for themselves. And I'm trying to think of a name that was suitable. Let's call him Tom. So Tom goes off and buys a house, and Jane and John lend him or give him the deposit, let's say £100,000 for his first home, which is, I think, seems to be typical these days. And again, Tom, bless him, gets in a relationship, they marry, divorce. Suddenly that deposit is gone, or half of it's gone to the girlfriend or wife, or whatever, by either lending that deposit or by gifting it via a trust. Because it doesn't legally belong to Tom, whatever happens in his life, it can't be, again, dissipated, it can't be lost. There's situations, again, where people don't realise that if that was something that happened, say, 5 or 6 years ago, you're allowed to backdate that protection. A good example of that is, some of you are old enough to remember Margaret Thatcher allowing council house owners to buy the council house. Now, by definition, that generally those people come from lower income, and it could well be that their children have made money, left home, and they may have either lent the money to the mum and dad to buy the council home, or bought it themselves in their name. Now, the complication with that, of course, is that when mum and dad want to move from that council house because the circumstances have changed, there's capital gains tax to pay, or if it's the money's being lent to mum and dad, they find themselves going to care, and so the house is lost care fees. Again, the protection for that can be backdated right back to day one, rolled back and put into a trust arrangement, whereby the mum and dad are beneficiaries of that trust. The son or daughter are the trustees and the settler of that trust, the person who created the trust. And because they're living in the family home and they are beneficiaries of that trust, it benefits from private property relief, and which means there's no capital gains tax on the disposal, and also there's no inheritance tax should the council tax home sort of go up in value. I used to live in a council tax home. It's called the Barbican, and they are massively valuable, and that sort of planning can be done to protect that sort of thing. Other things that we talk about generally for those who are much older in life, probably in or approaching retirement, is the aspect that the family home could be again assessed for care fees, and there's sort of a disparity at the moment in that you could have someone in the same care home who stayed all their life, and they're having to pay their own care fees, where someone who has not been able to save all their life is funded by the local authority, but they're getting the same care. So because of the unequalisation of that, people think that's a bit unfair. So we can protect the family home either from or at the point of death from care fees for the survivor, or indeed for both of them in their lifetime from care fees. The common situation I come across is where husband and wife, one of them sadly is in care, they own the home jointly, which is again quite common, and the person who's not in care is concerned if they were to die, by definition the house will then pass to that spouse who is in care, and now the family home is accessible for care fees and could be lost. It only takes a couple of years of being in care, and the fees can ramp up quite rapidly. And one of the things we talk about to clients is, well, what you can do is separate the ownership of that family home on a 50-50 basis by what's called a non-mutual deed, and basically means that the land registry recognise the person in care owns half the house, the person not in care owns the other half, and on their death, the person who's not in care will pass through their will, through trusts, and therefore can't be assessed for care fees. Obviously, the other half will be accessible and may be lost. Surprisingly, it's only 23,500 is the amount of savings you need before you start self-funding care. And if you've got care fees ranging at £1,000 a week, which in my area is quite common or usual, you can see it's not going to be long before care fees sort of disappear. And that's the real thing that I get involved in terms of more than wills, because wills themselves are, a will on its own, as I said, is about as useful as a chocolate teapot. It will describe where assets should go to, but there's no longer term protection for the wealth. And if you've worked hard and you've built up savings, the last thing you want to do is lose them to either taxman or in-laws or complete strangers.